Thank you all for coming. Thank you for finding this room, which I found to be the biggest challenge of the conference so far. Today we're going to talk about ethics in probably a different way than it usually gets discussed. As some of you know, there was a big controversy within and outside of APA, resulting in a controversial report commonly called the Hoffman Report. And there are some really widely divergent perspectives about the report and what it says about APA and what it means for us as an organization going forward. In my opinion, America is being ruined by confirmation bias. Everything is one extreme or the other, and people are seeking information that supports what they already think, and we're forced to make choices between two pretty diametrically opposed ideas. And I don't believe that that's a very good way to run a country. I don't think it's a very good way to run an organization. And what's been missing from, in my opinion, from the dialogue is kind of some just respectful, sensible dialogue about how to balance the rights of individuals with the rights of communities and collectives and countries, how to do harm, as least amount of harm as possible, and how to do it ethically, and what the role of public safety and national security and the appropriate role of psychologists, and how to fill that role ethically. And I brought in three genuine experts to talk about this, and here's the format. So Stephen Reisner is going to go first, Mark Staal is going to go second, Randy Otto is going to go third. They're each going to present in 10 minutes the basics of the position that they want to share. Then there's going to be a round table between the three of them, and I'll ask a couple of incredibly insightful questions if they have trouble, because they're all pretty quiet people. None of them will want to talk unless I force them. And then I'm going to open it up for the last probably 20 to 30 minutes for the audience. And Tom Grisso, who was my co-conspirator in putting this together and helped us conceptualize this whole idea, is going to have the mic. And here's the rules. Please don't filibuster. If you have a question, it's like Jeopardy. Remember to state your question in the form of a question. If you have a comment, please keep it brief, and then either the panel may or may not choose to respond. But I expect a fair number of people are going to have something to say. So try to be respectful of your neighbors, and especially of our panel. This is a controversial issue, and it takes a little bit of guts to say your piece in front of, I'm sure there's going to be people that disagree with everybody up here about something. If not, I will, just to be helpful. But please, let's keep this to be, I want this to be prospective and productive and constructive about our future as a science, a social science, and a practice, rather than looking backwards about what may or may not have gone wrong. Okay? So first of all, I'm going to introduce Stephen Reisner, who is a psychologist and psychoanalyst in New York City, and many of you know Stephen's name as he was one of the leaders of a group of people who, I think it's fair to say, took APA to task for what he believed to be some of the activities of psychologists that he believed were unethical. Is that a fair way to say it?
I would say that we're unethical.
Your floor is yours, Stephen. Please welcome.
Thank you. It's a pleasure to be here. My flights were all canceled yesterday, but I managed to get here this morning, so I really am glad to be back on the ground safely where my destination was. So, I kind of want to couch the discussion in a context of ethics. And so I put together 3 questions. One, first, what is a profession, and what are the obligations that members of a profession have? I'm bringing up the question of whether professions actually have unique obligations as professionals. 2, why do we have professional ethics? Especially speaking to this particular division, the question is, shouldn't law be enough for us? And why do we have ethics separate from law? And third, if we accept that there should be professional ethics, who should decide what they are, and what conditions are necessary to uphold them? I bring those up because I'm speaking about a piece of history where one particular profession was tasked to use its skills in a way that has been universally condemned as unethical. And of course, I'm referring to health professionals and torture, inhuman, cruel, inhuman, and degrading treatment. Part of what made this possible was the fact that in 2002, the APA Ethics Code was changed to put law above ethics. It said if there's a conflict between ethics and law, a psychologist can follow law. And 3, this all took place under conditions where there was no oversight or very, very limited oversight, and that has to do with national security environments. So I think that what we have in our history is an experiment in freeing a certain group of psychologists from ethical oversight, following law instead of ethics, and allowing the profession to be used as part of another agenda that is distinct from our professional agenda. So let me give you a little history. And I'm going to start in 2001 with September 11th. September 11th happened. There was a huge effort, of course, on the part of our nation, our military, our CIA, our government, to protect us. And for our purposes, the one important thing that took place at that moment, right after September 11th, was that this manual of al-Qaeda operatives had been discovered and was forwarded to a CIA psychologist named Mitchell. Mitchell saw this as a resistance manual, training al-Qaeda operatives in resisting interrogations. And he and his colleague Jessen, Mitchell and Jessen, created eventually Mitchell and Jessen Associates, and they created a program aiming to overcome the resistance of captured detainees. And they worked for the CIA. They were paid $181 million to oversee the CIA's torture program. Okay. 2002, very soon after this, September 11th, of course, was in September. Mitchell got the Manchester Manual in December. Starting in January and February of 2002, we began getting good leads to capture some terrorists who were responsible. One such terrorist, Khalid Sheikh Mohammed, he's currently at Guantanamo. There was a lead about where he was living. The CIA went to his house. He wasn't there. His 2 sons, aged 7 and 9, were there. They were captured in his place and used to pressure him, first to pressure him to give up, later to pressure him to talk. You may question the idea of sending 2 children to CIA black sites and putting them in prison. It's a violation of international law. It's a form of torture. But the CIA said, we are handling them with kid gloves. After all, they're only little children. but we need to know as much about their father's recent activities as possible. We have child psychologists on hand at all times, and they're being given the best of care. Later in 2002, John Lesso, a psychologist, and Bernie, I don't remember Bernie's first name, a psychiatrist, were sent to Guantanamo. Mitchell and Jessen created a team of enhanced interrogation for the CIA. Lesso and Bernie were sent to Guantanamo and tasked with creating the same thing at Guantanamo in 2002. They also were trained in using the same tactics as Mitchell and Jessen, which were called SEER tactics: survival, evasion, resistance, and escape. And that's what gave these people the expertise, supposedly, to break resistance. Lesso and Bernie were, under the advice of two other operational psychologists, Larry James and Morgan Banks, were sent, wow, that was 6 minutes already, okay. Were sent to Fort Bragg and trained in SEER techniques, and they created a torture manual. The torture manual basically permitted sexual humiliation, interrogations 20 hours at a time, hypothermia, smashing people into walls, and each of them were present during those interrogations. We know that at Guantanamo there were abusive interrogations going on pretty much nonstop, and worse, abusive conditions that were overseen by the biscuits. That included isolation, absolute isolation for the first 30 days when you arrived. You were not allowed to see members of the International Committee of the Red Cross. You had to only speak to your interrogator if you wanted toilet paper, et cetera, et cetera. I've only got like 2 more minutes to tell you that this was all exposed by the International Committee of the Red Cross, which for the first time in its history leaked a report because the conditions that they found were A, untenable of torture, and B, that the United States was not doing anything when they reported to the United States that torture was going on. They found not only was torture going on, but it was being overseen by health professionals in violation of their ethics. Cut to a few years later, because I have 1 minute to finish this story. It turns out that when this was exposed, the physicians, the doctors, the psychiatrists, the nurses, their professional association said this is a violation of our ethics. The APA put together a PENS task force with the majority of operational psychologists to decide what the APA's policy was, and not surprisingly, they did not find any reason to prohibit psychologists from being involved at Guantanamo in these operations, probably because Larry James and Morgan Banks and Scott Shoemate and Mike Gellis, 4 of them, had been to Guantanamo or to CIA black sites as part of operations there. The rest is history. We discovered that APA refused to change its policy, even though the membership passed a referendum demanding that APA not allow psychologists to be at sites where there is systematic violation of international law, but they continue to do it. We didn't know why. There were 2 revelations of emails. One was by Hoffman, one was by James Reisner in the New York Times. Those revelations showed that the APA colluded with the military, with a group of operational psychologists and with a group of CIA psychologists to help develop the techniques that were used in the program, not knowingly necessarily at the CIA, but certainly knowingly at Guantanamo, and that group of operations psychologists influenced APA leadership to prevent any change in policy. Once that was exposed, we finally had a change of policy. It took the expose, it took 10 years, but we finally have a policy now in place that prohibits psychologists, like physicians, like nurses, like psychiatrists, prohibits psychologists from being involved in national security interrogations, and goes further. It prohibits psychologists from being present where there is systematic violation of the Geneva Conventions and international human rights law, and as a result, psychologists were removed from Guantanamo Bay. Thank you.
So our next speaker is Mark Staal, who is the president of Division 19, which is military psychology. And he told me that's all I was supposed to say. So he's a really nice guy.
Thank you, Joel. So let me say thank you to Stephen, thank you to Randy for sort of sharing this opportunity, thank you to Tom, thank you to Joel for making it possible, thank you for giving me an opportunity to share my position. I will break with good talking protocol by telling you what I'm not going to do before I go ahead and do something different. I'm not going to defend the CIA. I'm not going to defend the Bush administration, the Trump administration, the Obama administration. I'm not going to defend the DOD and its decisions. I don't represent the DOD. I represent my opinion. However, I would say I think that my views on the things that I am going to talk with you a little bit about are shared by a lot of operational psychologists in and out of the military and in national security. With that, I'll begin. Operational psychology, for those that aren't familiar, is a form of applied psychology. It's an ethical practice within our profession. Operational psychologists do many things. They work in public safety, defense, security, and intelligence, where clients may be third-party decision makers or organizations as opposed to individuals receiving personal services. They often focus on organizational effectiveness as opposed to personal effectiveness. And while they do many things, some of these things, they help assess, select, and train resiliency in military members. They enhance communication, team cohesion, and leader decision-making in high-stakes situations. They advise interrogators and intelligence analysts on the best ways to build rapport, operational accord, and cultural sensitivity when working with detainees. They train pilots to reduce cognitive load, enabling them to better accomplish their missions. They consult with organizational leaders on morale, personnel, and policy. In some instances, their work is classified, with limits placed on external access. When acting as embedded consultants, dual agency considerations are common. As a result of this specialization's unique characteristics, it's come under significant criticism from a small vocal group of opponents. The following position statement will address 3 critical efforts used to attack operational psychology in the last few years. All right? The first one, a false dichotomy, an attempt to split psychology, operational psychology, into adversarial or collaborative frameworks. The second, a false narrative, the APA's Hoffman Report, which concluded that there was collusion between the APA leadership and senior DoD psychologists. And the third, a failure in principles, the Brookline Principles Report, a document drafted by critics of operational psychology intended to codify practice guidelines for operational practitioners. I only have time to touch the wave tops on each one of these, but I do believe that the water is murky beneath the surface. The first one, a false dichotomy. In 2012, authors critical of operational psychology proposed a split in the specialty. They asserted that when psychological practice contains limits to informed consent, unstipulated harms, or insufficient oversight, it should be considered adversarial. The authors contended that this criteria only applied to operational psychology and no other specialties. They assert that when psychologists are engaged in adversarial activities, they should be stripped of their licenses. They should be removed from the APA and prohibited from calling themselves psychologists. A thoughtful response exchange has already occurred in Peace and Conflict, the Journal of Peace Psychology in 2015, and I would refer you all to that series. I will briefly touch on each criteria. According to this criterion, lack of informed consent, we would reject most third-party consultation. In such instances, the client is often not the subject of the psychologist's services. The psychologist and the subject may never even meet, and therefore, it may not be possible or reasonable to secure all non-clients' consent. The APA Ethics Code makes provisions for this limitation. See 3.07, third-party requests for services, 3.10, informed consent, and 4.02, limits to confidentiality. The second criteria, presence of unstipulated harm. Although the authors state that their concern is unstipulated harm, in practice, they appear to suggest that psychologists should not harm. My colleague who just got done speaking has made that very clear. In an interview to Al Jazeera in 2015, he stated, the line is very clear, do no harm. And that when psychologists do, they aren't acting as psychologists. Those impacted by a psychologist's services, again, may not be the identified client. It may be unreasonable or impossible to contact all individuals to stipulate any and all potential harms. The authors conclude that if psychologists do harm, they're adversarial and shouldn't be considered psychologists. This is overly simplistic. Grisso in 2001 amply noted that psychologists often do harm, but do so ethically. We breach confidentiality, we triage medical necessity, we conduct research that may manipulate or deceive, we report individuals to state agencies, we render testimony that separates parents from children. The APA Ethics Code does not place a premium on our obligation to individuals over and above our obligations to society. 3.04 standard of the APA Ethics Code acknowledges that psychologists at times will do harm. Our ethical obligation is to mitigate it whenever it's reasonably possible to do so. The third criteria, lack of external oversight. Psychologists working in the military and intelligence community often require security clearances. External agencies will have limited access to their work in certain instances. The authors argue that such limits result in the ability to hide unethical conduct and resist external investigation. However, external access to psychologists' work is often limited. Therapist notes may require court injunction to secure. Business marketing research and strategies may be proprietary and highly confidential. Court files may be sealed. If there have been cases where state or national investigative bodies have looked into psychologist records and been denied based on the argument of national security and defense, this should be made known. I am not aware of a single instance where that has taken place. Divide and conquer has been this group's name of their game. The decision to bifurcate operational psychology is both strategic and political, in part based on a decision to separate the military and intelligence psychologists from their civilian counterparts. I'll give you several examples in the civilian community that would be considered adversarial by this group. Jury consulting, child custody evaluations, advising businesses and marketing firms where the client is the organization and not the consumer, advising law enforcement and public safety on criminal behavior, and operating in corporations identifying internal threats to company security. These examples include limited informed consent, limited external oversight, and the potential for unstipulated harm. They are adversarial. These criteria, if equitably applied, would implicate many areas of specialization across American psychology. Thousands of psychologists would find themselves cloven from the APA and their peers. Such a separation is a false dichotomy, is unnecessary, and is not in keeping with the best practices of our profession. The second front, the false narrative, the Hoffman Report. Excellent critiques of Hoffman are already available. I would turn you on to the Division 19's Task Force Report, Hoffman Report, APA.com, and Dick Kilberg's response from last year. As a result, I'm only going to refamiliarize you with the facts. As this audience knows better than most, lawyers operate out of two main modes, criminal indictments and civil torts. Such processes are adversarial by their nature. One lawyer or legal team presents an argument alleging harm. The other team presents counter-arguments alleging that that harm didn't take place. And all of these arguments take place in front of adjudicating bodies, a judge or a jury, who will assess the veracity of those claims. In contrast, psychologists are trained to conduct science, and it's through that lens that we evaluate data. We start with a proposition, a null hypothesis, a logic statement used to force critical thinking and a comparative analysis of facts. These two different approaches to investigation lead to very different conclusions. Consistent burdens of proof, sound methodology, critical thinking, and an understanding of bias were notably lacking in the Hoffman investigation. Division 42, Psychologists in Independent Practice, one of the largest APA divisions, issued a vote of no confidence resolution in the board of directors' handling of the Hoffman Report. So what? That was almost 3 years ago. I hear that all the time. I've heard it from folks here who've heard that I was going to talk about the Hoffman Report, and they said, Mark, why don't you move on, right? Let me explain why folks from my community struggle to move on, because we're living with a sandwich that we're being asked to eat that is just unfair. Let me give you 4 reasons why. Post-Hoffman, the atmosphere has become polarized. All right? You either swallow the whole thing and you like the whole report and think it's justice and righteousness, or none of it. Our members of my division and my society are named in that and have been indelibly smeared. The resulting APA policy prohibiting psychologists from supporting national security interrogations is a first. The APA is essentially outlawing a location or a setting and not a behavior and not conduct. The prohibition against military psychologists from providing mental health care to detainees is a violation of Common Article 3 of the Geneva Conventions, accepted U.S. international law and treaty. We must provide mental health care to detainees under our detention. This means that now the APA is either forcing us to follow law and U.S. treaty or their policy. The last category, the Brook line of failure and principles. Under the banner of Coalition for an Ethical Psychology, the Brookline Group intended to discuss ethical issues associated with operational psychology, consider the adversarial collaborative framework, and draft operational guidelines for operational psychologists. Yet they failed to include a single operational psychologist or anyone working in national security psychology on their group. How could they ethically create practice guidelines for a specialty that none of them practiced? The Brookline Report had much to say that was inaccurate, and I have only time to address one statement. Brookline asserted that operational psychologists are under too much pressure as dual agents to act ethically. This contradicts the account of Dr. Michael Gellis chronicled in Mark Fallon's book, Unjustifiable Means, and Paul Lauritsen's book, The Ethics of Interrogation, ironically Paul being a Brookline member himself. Mike was the chief of operational psychology for NCIS in 2002, and he visited Gitmo. He reported abuses immediately to the NCIS director and their Office of Legal Counsel. Mike was a DoD third-party consultant and military operational psychologist. All the dynamics were present that critics say would prohibit his autonomous moral agency, and yet he spoke out and did so without hesitation. In summary, I've worked in this field for over 25 years. As a military operational psychologist, I've deployed to multiple locations overseas, totaling 3 years in Afghanistan and Iraq alone. During that time, I would estimate that I've observed over 2,000 hours of interrogation in multiple theaters and across multiple facilities. I've never seen someone waterboarded. I've never seen someone tortured. I've never felt unable or inhibited to speak truth to power. It's part of the ethos of military culture to stand up for what is right, what is just, and what is lawful. It has made addressing this disinformation campaign so painful and frustrating. If psychologists behave unethically, they should be sanctioned, reprimanded, or criminally prosecuted. We don't find fault with clinical psychology when a clinician sleeps with his patient. We also don't prohibit practice settings or locations. We prohibit behavior and conduct. Operational psychology is an ethical practice in our profession. Thank you so much for listening to and considering my position.